Good evening, everyone. I hope you all are doing great and are as excited as I am to embark on this incredible learning journey. On behalf of Legal Vidya, I welcome you all to the live webinar on Principles of Interpretation, Bridging Law and Justice by Legal Vidya. Before we dive in, let me extend my heartfelt gratitude to each one of you for trusting us and choosing Legal Vidya as your learning partner. We promise you an enriching and transformative experience that will expand your legal knowledge and prepare you for real world challenges. To kickstart today's session, let me share a bit about who we are and what we stand for at Legal Vidya. Legal Vidya was established in 2021 with a mission to revolutionize legal education through the power of online learning. We are more than just an edtech platform. We are a community of passionate learners and legal professionals. From internships and workshops to webinars and comprehensive courses like the one you have joined today, we offer a wide range of opportunities to help you grow in the legal field. What makes us unique is our focus on not just theoretical learning but also practical application through real world case studies, discussions, and mentorship. This webinar on principles of interpretation Bridging Law and Justice has been meticulously designed to give you a 360-degree understanding of statutory interpretation and its application in real world scenarios. Over the next 60 minutes, we'll learn the statutory interpretation in legal profession, fundamental principles such as literal rule, Golden Rule, Mischief Rule, and Purposive Approach, landmark cases and judicial precedents, and also we will be discussing the challenges in interpretation. Through this session, you'll gain insights into the real world scenarios. Our primary objective is to help you understand the role of statutory interpretation in legal profession. Secondly, role of interpretation in ensuring that the law remains relevant and adaptable while maintaining fairness and justice. By the end of this webinar, you will be equipped with the knowledge needed to interpret law. Now, let me introduce the person who will lead this amazing journey, Miss Akansha Singh. She is a distinguished legal scholar, educator, and researcher with a deep commitment to advancing legal education and scholarship. She holds an LLM from National Law School of India, University Bangalore, one of the India's most prestigious law institutions, and a BLLB from GGS IPU, New Delhi. With over 6 years of teaching experience, Ms. Singh has held key academic positions as an assistant professor at Symbiosis Law School, Pune, Lloyd Law College, and Presidency University, Bangalore, among others. Currently, she serves as a faculty and mentor at Live Law Academy, where she plays a pivotal role in mentoring aspiring legal professionals. Before we start today's session, my only request will be to feel free to actively participate, take notes, and ask questions during the session. Remember, your engagement will make this learning journey all the way more impactful. So, without any further ado, please join me in giving a warm virtual welcome to Ms. Akansha Singh. Over to you, ma'am.
Thank you so much, Khushbu. That was a very generous introduction and uh, welcome everybody. Am I audible? I'll just need a confirmation with regards to my screen also. I'll share my screen. Please let me know if my iPad screen is visible or not. Okay,
Yes,
just give me
ma'am,
a.
you are audible.
Yeah, is this screen visible now? The one with a lot of documents?
No, ma'am.
Okay, you can't see my other screen. Um, all right. Just a minute. I'll just see. I'll try everything so that maybe. Okay, now. Is my iPad screen visible? Are the documents visible?
Yes, ma'am, it is visible.
The documents are there, and I am also visible, right?
Yes, ma'am.
Okay, all right. Thank you. Thank you for confirming, Khushbu. So, good evening, all of you. So, we are here to understand interpretation. Very interesting topic. And as she was asserting on, for you to understand how does the practical aspect of the law that you study in your college really works. Okay. So, I'll take you through a few judgments. Before that, let's just discuss and try to understand what is really interpretation and what is the impact of it and how is it going to be beneficial for you in your college or in your practicing journey. Okay, so you have to first, and you all can participate. I believe you have you all can message in the chat box, so you can let me know how many of you have ever read an entire judgment on your own or in your college. How many of you have read a judgment? You can raise your hand also. All of your clappings, it's absolutely fine. Okay. So, okay, very good. All right, very good. Good number of people have read judgments. All right, that's great. So, the idea here is that when we read judgments, there are different. What is the role of the judge? When given the facts, they have to apply the law and they have to conclude, right? Now, in this, the bridge here between the fact and application and the outcome is what? That is with regards to finding out that what does the law really say. And it is not easy that always the law will give you precise definition or the law will give you definition of each and everything. And that is where the role of interpretation comes into picture. Why do we see so many judgments? So I believe it was just 2 days prior that a judgment has come with regards to how if there is an employer-employee relationship and the employer has put a clause that the employee cannot leave before 3 years before they complete 3 years in the service of that bank or of that PSU, any private company. If they really want to do that, they will have to pay a certain amount of money. So this is basically called as bond system, right? That in very lucid language we say that okay, हमें bond पे हम bind हो रहे हैं और अगर हमें छोड़नी है job, so we will have to pay a some amount of money, right? Now, all of us, if we start thinking about it, and from our preliminary understanding of Section 27 of the Indian Contract Act, what do we really feel? We feel that, this should not be allowed because this is restraining in trade. We all would want to switch our companies. We all would want to get a hike. Now, is this something that the judiciary also thought of? The Supreme Court has mentioned that this is absolutely fine. A company putting a clause that if you want to quit this company within 3 years, you will have to pay me 2 lakh of rupees. This clause in that agreement has been considered to be valid. Now, why has the court really held so? The idea now comes for us to find the reasoning, and the reasoning more or less always will have the interpretation of a section, interpretation of the law that has ambiguity. And that is what we really have to understand. So Khushbu has mentioned a few rules of interpretation. Before getting into that, I will just take you through a very simple example of your cafeteria, college cafeteria days. Okay, so let's just I hope this is visible to you. I'll draw something here. Let's say if you go to your college cafeteria, just let me know, okay, whether this whatever I'm scribbling here is visible or not. Is this scribble visible? This is visible?
Yes, ma'am, it is
Okay,
visible.
all right, all right. So let's say you go to your college cafeteria. The college cafeteria has a menu card. Okay. Who has made this menu card? The person who owns the cafeteria. Now, in the very similar manner, we will now again compare this menu card with the law. We have a law. Who has made this law? It is the legislative body, right? Now, when the college cafeteria owner wants to serve you certain beverages, he has mentioned a list of beverage. Okay, they have mentioned we have coffee, we have tea, we have lassi, and yes, that's it. Okay, and in the food items, they mentioned that food items we have a burger, pizza. Okay, what else? Fries. etc. Now you go to the canteen and you are in a mood to have maybe, let's say, mojito. Okay. So in that situation, where if that is not mentioned here, how will you find out whether he will be flexible enough to make mojito for you or not? Okay. And here there is another term, etc., that is written. Okay. Or maybe in the beginning it is written that we make food items including this. Now, for me to understand that whether these are the only three items that he will give us, or there can be other things also, I am going to find out and I am going to see what is his intention. And what am I trying to do? I have to read his intention. So, because this person is in front of you, you can go and simply ask him, and maybe you will get clarity with regards to what does he really means here. But for every ambiguity, do you think the judiciary, when they are again dealing with something which is written in nature, written by written by virtue of law, right, by the legislative body, and now if there is ambiguity, if my law says that there will be tax, and these are real time examples that I'm going to tell you now. Okay, so there will be tax imposed on vegetables. Now what is vegetable? Vegetable includes, in the next provision they have defined, vegetable includes this, whether it will include sugar cane or not, whether it will include ginger or not, whether it will include coconut or not. These are all cases that have been decided by the court with regards to finding that whether these are vegetables or not. Why? Because in the law it was mentioned that tax will be imposed on vegetables. Are these vegetable? Do you think practically the legislative wing can define vegetable in an exhaustive manner? No. So here lies ambiguity, right? And interpretation comes into picture whenever there is ambiguity in law. So this was a very simple example for me to tell you that whenever the law has certain ambiguity, here comes the role of interpretation. What type of interpretation will be done here, and what are the different means of interpretation? Okay. So what will be the type of interpretation? That is one thing that we can understand. And what are the different means of interpretation? We have very less time, so I was thinking maybe, I'll just cover everything in a little manner, and then I'll take you through judgments from the last year for you to see as to whatever I have taught you or whatever I'm telling you is actually there in the judgments or not. So what are the different type of means or helps or aids available to the judiciary for interpretation? So they have certain type of internal and external aid. I have already told you that when does the role of interpretation comes into picture? It comes into picture when there is ambiguity in law. As I told you. Now section 27 does not mention that this type of a clause which restrains a person for a few years in working. 27 doesn't talk about it. It talks about restraint in trade. And now I am not restraining in you in your trade after you have left my job. I am restraining you while you are working with me. And in case you want to go, now you have to pay a some amount of money. So there was ambiguity which the court has addressed just 2 days prior. So in such a situation, the judges have to opt for aids. Okay, these are help or means available to the judiciary for them to find out how to fit this ambiguity. Now, there are two categorization of aids, internal aids and external aids. And mind it, whatever you are studying today, you will read it when you go, whatever your specialization may be. Okay, if you are into penal law, if you are into tax law, constitutional law, everywhere you will see, and I will take you through judgments also, environmental law, all these laws will apply the same principle of interpretation, maybe in different manner. And that is why I have written types here. Okay, so I'll come back to this. But the idea is that it is applicable everywhere, and that's why you should just understand maybe a gist of it. Okay, so there are internal and external aids. Now, in our colleges, in our college days, even when I was a student, we used to just mug up that, okay, preamble is an internal aid, marginal note is an internal aid, head note is an internal aid, right? External aid, right? So whatever, we used to just simply mug it up. Now I have judgments to show you, for you to really identify law, for you to really go through it and see that how is this going to help. So I'll start with internal aid. Do you have any answers as to what all can fit in internal aids? Yes, anybody wants to answer? What all will fall under internal aids? In the chat box, maybe? Illustrations. Okay, Navya has answered that illustrations are part of internal aids. Okay, okay, very good. Preamble, explanation. Okay, precedence will be external aid. Okay. Short title, very good. Short title, long title, articles, or the title of the particular um, thing that we are studying, right? Okay, very good. Definition clause, interpretation clause. What is the distinction between definition and interpretation clause? In most of the law, you see that they use the term definition clause, mostly in section 2 or section 3 of the law, right? But Indian Contract Act, you will see they mention that it is interpretation clause. Section 2 has this title, interpretation clause. Okay. That is to provide flexibility, right? So how did we understand that the legislature in 1872 provided us the window that later Akansha or later Navya, Aarti, Juveria, later if you have to find out whether e-contract is also a contract as per section 2H, then in that situation you have the flexibility. Why do you have the flexibility? Because it is an interpretation clause and not merely a definition clause. So these are ways, these are hints that the legislature leaves to us by internal aids for us to understand whether something more will be added later or not. Okay. Yes. In TP also interpretation clause is there. All right. Now, so we were discussing that there are different type of internal and external aids, okay? And it is not that one law will be read in isolation. There are multiple laws that are read together. For example, let's go to Indian Contract Act, okay? If we see Indian Contract Act and we will compare and we will read it with Specific Relief Act and Transfer of Property Act. Now, India, is it important? Is it mandatory that every contract has to be in writing? No. Where is it mentioned? Because first, Indian contract is silent about it. Second, when we read section 10, right, we understand from the reading of section 10, this part, okay, the one that I'm going to highlight in pink, section 10, part 2. It basically gives us an idea that this can be read with other laws as well. And what are those other laws? Other laws are Transfer of Property Act, which also tells you that there can be a written contract. So we understand first when we read these provisions. Then in addition to this, we also see that the preamble here allows us to do the same. What does the preamble of Indian Contract Act tells us? It uses the term whereas it is expedient. Okay, you can't see the provision. Yes,
Apology
yes, yes.
for yes.
I'll go there. I'll go there. I'll go there. 1 minute.
Yes, ma'am.
Yeah, thank you. Thank you that somebody highlighted. Yes. So when you read the preamble, simplest of thing, okay, a law will use either preamble or long title. These are called preamble or long title. Okay, this is called the title of any section. Then you have chapters. If you see when we go to Transfer of Property Act, it has specifically divided chapters. Sale will be in one chapter, gift will be in another, lease will be in another. So all these divisions have been done, which gives us an idea. In fact, merely when I read the title of the law, Transfer of Property Act, is it only for immovable property? No, because we have used the term property. So the legislature, by all of these means, by all of these internal aids, are helping you. Okay. So the preamble, let's refer to Indian Contract Act. It says define and amend certain parts of the law relating to contract. Now, from this, how do you think we get an idea that a contract can be in writing, not as per Indian Contract Act, but maybe other law? Which is that term which is mentioned here, which gives us an idea merely by reading the preamble that it can be done by any other law as well. Yes. Anybody wants to answer? I was showing you the screen, and the question there is that how, from reading of this preamble, we get an idea that a contract can be in writing as well. Maybe not as per Indian Contract Act, but other law. Any answers? Okay. Okay, I will definitely go to IPR also if that is required. Nobody has answered, so I'll just take you through the term that is used. The legislature has used the term certain parts of the law relating to contract. That means that from the reading, I have not even started reading the sections of Indian Contract Act. Merely by reading the preamble, I get an idea that Indian Contract Act only and only covers certain parts relating to the contract, and definitely there can be other laws which have different parts as well. Okay, and that is where we realize that it can be in writing as per Transfer of Property Act, right? Then there is a meaning related to why the term expedient has been used, why the term define and amend has been used. Is Indian Contract Act exhaustive in nature, or is it inclusive in nature, or is it something which is complementary to other laws? From the reading of the preamble, we can answer whether it is exhaustive, complementary to other law. Tell me, what is it and why? What is your answer and why is that your answer? Whether Indian Contract Act is exhaustive or illustrative. Oh, okay, very good. It is complementary. Okay, yes, because it does not uses one term. What is that term? If I would have used that term in the preamble, the internal aid would have told me then, this preamble would have told me then that this law is exhaustive in nature. Anybody wants to answer? What is that one term? When we use the term consolidate, if you see in Indian Evidence Act, we use the term whereas it is expedient to define. Yes, define, amend, and consolidate. Consolidate gives us an idea that this is an exhaustive law in its own. Okay, so now this was just merely to just give you an idea as to. I'll now take you to the judgments. Okay, this was merely to give you an idea that there are different section in different law. If you go to Specific Relief Act, therein section 2E tells you very clearly that we can't define everything here. So whatever is required, refer to Indian Contract Act for the definition. Now, for reading of SRA, Indian Contract Act becomes external aid. So there are internal aids which are present in the reading of this law, within this law, which can be the illustration, which can be the title, which can be the explanation, which can be the defenses, all of this, right? At the same time, you must have seen, if you read any judgment, they usually quote that as per Oxford Law Dictionary, as per Blackstone's Law Dictionary, right? Why are they referring to the dictionary meaning of a term? Why are these judgments, why do they talk about the dictionary and the definition of dictionary? For example, property is not defined. Okay, now go back in time and try to see how did we recognize, how did we really, when we were living in a society where everything was either tangible or intangible, or mostly tangible in nature, how at that point of time we would have thought that okay, IPR will also be a property. So property is not defined. Then we start looking for the legal definition of property, not mentioned in the law but mentioned in different dictionaries. And that is why in judgments, whenever you see, they refer to these sources. If you start reading Indian Contract Act judgment, okay, I'll just see if I can show you any example. these judgment, these old judgment uses a lot of books, okay, in their explaining of whether what will be covered here or not. I'll just see if I can find any of these judgments for you. So, what is the idea of mentioning the books or the authors of book? The idea is that this is also an external aid. Okay, then we have to refer it from other sources. Yes, right. General Clauses Act is the, so if first and foremost we will go to any of these laws only. Okay, if the laws are silent, if let's say the law General Clauses Act doesn't cover it, then in that situation we can use other external aids, which can be, first it can be the dictionary meaning. If the dictionary meaning is not there, legal dictionary, okay, not any other dictionary, then we come to whether there are books that have tried to explain it. So we have Fifth, right? We have other books wherein we have defined a lot of terms. Imagine when you go back to your contract law classes, we used to study that there were postal rules, and after that came the instantaneous mode of communication. Now, e-contract, what is that? So, no, I am not presenting anything right now. I'm speaking right now. So, these are different aids that are available to us. Okay. So, the next aspect that I wanted to tell you was that first we have internal aids, then we have external aids, which can be other laws, which can be precedent, which can be foreign laws, laws from the other jurisdiction, other practices, common law. Okay, then we have books, we have legal dictionaries. All these different things are going to help us externally, even though not present in the law, but the judiciary is allowed to opt for those and try to get explanation or clarification while deciding something. Did you understand what are internal and external aids? Then I'll move to what are the different types of interpretation. Okay. What if two author books on the same matter? So basically, see, it's not that they are bound by whatever is mentioned. If you read a judgment, it has to be holistic. Okay, so if let's say there is ambiguity and I have to address that ambiguity, if let's say I have to find out whether coconut will be, and this is from judgments, right, whether coconut is a vegetable or not. So the court will here see what is the legal definition, if at all anything is there, how coconut has been defined in other dictionary, whether they have defined it to be a vegetable or not. Then they will also see that what is the use of coconut. And that is where we come now to the next point as to which rule do we really apply for. So in this case, we will now apply and opt for purposive rule of interpretation. What is the idea of imposing tax or exempting vegetables from taxation? If there is a tax law and the tax statute says that there will be no tax imposed on vegetable, what is that? Why do you think the legislature has said that the vegetables will be exempted from tax? Because that is something that is used by everyone. That is something that is used on everyday basis. Yes, Muskan is written necessity, correct? So unless and until it is presented on the counter, it is something which is packaged. In that situation, vegetable will not be imposed any tax. Now, when we are addressing whether sugar cane is a vegetable or not, what will be your answer? If you if you have to find out whether sugar cane is a vegetable and whether it will be given this exemption, no, why not? Even though it is rooted, even though it has the same thing, it will be a seasonal crop, but we will still not consider it to be vegetable. Why? Because the purposive rule of interpretation. What is the purpose of law here? The purpose of law is to not impose tax in a way which is going to affect the people in their everyday life, right? So this was a layman example. Now what we can do is we can go to judgments and try to see that how the judgments have referred to and how they have actually addressed these things. Okay. But we use sugar every day, but that is a byproduct, right? So Darshan, there is a case of state of Uttar Pradesh versus Lalta Prasad. That is an amazing case, because you've mentioned it here, for you to see that how the law basically differentiates between two things, the byproduct and the raw material. So it is a case about industrial alcohol. Okay. um, yeah. So, State of UP versus Lalta Prasad decided, I think, in 2024 or early 2025, wherein there are different entries. And if I had time, I would have explained it also. So, it's a lengthy judgment. Basically, refers to different entries mentioned in the schedule, seventh schedule of Indian Contract Act, wherein they have spoken about three terms. They use the term alcohol, they use the term industrial alcohol, and you have to find out whether alcohol and industrial alcohol are same or not. So that has been done on the basis of what intoxicating alcohol is there. We use alcohol in sanitizers, we use alcohol in our home cleaning things as well. In our perfumes also there is alcohol. So then they refer to intoxicating alcohol. Okay, I'll just see if I can find the judgment. There's one more thing that is very yeah, I have the judgment. I'll take you there. So if we refer to this, this is the case that I am talking about. Okay. When you see this judgment, 364 pages, you will see that there is conflict with regards to these entries that are seen here in the footnote. If you see, entry 33 is there, entry 8 is there, and entry 8 defines the term intoxicating liquor. Okay. And now they have done, I'm not telling you what is the extent of interpretation that the judiciary has to do. They had to now interpret that why has the legislature used this term. Intoxicating liquors, that is to say, the production, manufacture, possession, transport, purchase, and sale of intoxicating liquors. Now the question came that whether why this has been used here. What is the role of this? So in conclusion, they basically try to explain, and then they say that this basically is not used unnecessarily. We always have to first believe and presume that the law has been very mindfully codified. Okay. And therefore, and you do not primarily believe ambiguity. So primarily we believe that it is rightly codified. And then on interpretation, if we feel it is going against, then we say that, okay, the law has to be read in this manner. And that is why maybe in your CRPC class, you may have seen in certain cases, may is read as shall. Why? Because if we start reading may as it is in the literal term, then it may not actually serve the purpose. So purposive rule of interpretation, very important. Then we were trying to find out that why and how do we see these terms. So the court has ultimately declared here that this is used to basically define. They have rather than using the term means, they have said intoxicating liquor. That is to say the production this. Now comes another question, that whether the term means or includes, what is the distinction between the two? So if somebody was talking about IPR, right? Now, if I start saying literary work includes this, can we give an exhaustive list of what all will be literary work? We cannot. So the law says that literary work includes, not means, rather includes. Now, what has the judiciary, what has the legislature done here? First, they have given you a hint when you are interpreting law. Remember that this is not an exhaustive list. This list has certain things, but there can be other things also that can be added. At the same time, you get an aid from the reading of these things. If let's say I write vegetable includes green leafy vegetable or rooted vegetable or fruits, okay, let's say hypothetical. So in the and other and such other products. Now for me to find out whether sugarcane will be included here or not, I will find out the meaning of all those things that are preceding and that are subsequently used. And these two rules are called as the rule of use them generis and nocitur associ. These are two different rules. Okay. One is use them generis, the other is nocitur associ. Nositur or soci. Associ means association. You are, आपके दोस्त जैसे हैं, उससे आपके बारे में बहुत चीजें समझ आती है, right? So you can be understood, your personality can be known from the company that you keep. Likewise, in law, what are the terms that are used before and after this particular word? If before other such products, they have used fruit, greeny vegetable, rooted vegetables, then in that situation, we will understand that maybe the legislature intended to have sugar cane also included in it, right? Not maybe, not coconut, but maybe sugar cane to be included. I'm just giving you a hypothetical example for you to know that when the legislature uses any term in whether when they use any comma, I'll give you an example of comma also. um let's say if we go to Indian Contract Act, we have a savings clause here. Yeah, we have this savings clause here. I'll highlight it in pink. You must have studied this in your college days as well, right? The savings clause here uses a particular comma that I'm going to highlight for you. This comma. This comma. It has a lot of relevance. Okay. Now, if you read the savings clause, I'm not explaining this, but let's just read it. Nothing herein contained shall affect the provision of any statute, act, regulation not hereby expressly repealed, nor any custom or usage, comma, nor any incident of any contract, comma, again, not inconsistent with the provision of the act. These two commas have a lot of relevance. So is this point which is written over here after the last comma not inconsistent with the provision of this act? Is it something which is applicable only with this, or is it something which is applicable with this and this as well? So basically the savings clause is saying what? The savings clause यहाँ पे ये बोल रहा है कि इस लॉ में, इंडियन कॉन्ट्रैक्ट एक्ट में जो भी मेंशन है, उससे कोई और एक्ट, स्टैट्यूट, रेगुलेशन इफेक्ट नहीं होगा, उससे कोई कस्टम ऑफ ट्रेड या यूसेज इफेक्ट नहीं होगा, उससे कोई इंसिडेंट ऑफ कॉन्ट्रैक्ट इफेक्ट नहीं होगा. और इसके बाद लिखा है विद अ कॉमा नॉट इनकंसिस्टेंट विद द प्रोविजन ऑफ दिस एक्ट. So this, as long as the incident of the contract, the term of the contract is not inconsistent with the provision of the act. So क्या एक custom और एक usage को भी consistent with the provision हो रहा है? Is this something which is applicable on this as well? Or if the custom is against the law, contrary to the law, will it be absolutely fine? So this was clarified by the 13th Law Commission of India, and they said that there is a reason of putting comma here. This comma suggests and says that it is not in continuity, and that is why it has to be read with all the three different categories, whether it is this, or the incident of contract. So that is how this is an internal aid, comma, full stop, with whatever we use here has a relevance, and that is how we have to read it. Okay, so I showed you this particular judgment. Now I'll show you another judgment. Okay, we have this case of Urmila Dikshit versus Sunil Sharan. 2024 का केस है, 2025 का केस है, ठीक है, decided very recently. Now what has happened here, this basically has a provision related to the Maintenance of Senior Citizens Act. Okay, so this is the name of the law, Maintenance and Welfare of Parents and Senior Citizens Act. And इसमें in question था section 23. Yeah, this is what you have in front of you. Okay, section 23, which says something, which says transfer of property to be void in certain cases, where any senior citizen who after commencement of this act has transferred by way of any gift or otherwise his property, subject to the condition that the transferee shall provide basic amenities and basic physical needs to the transferor, such transferee refuses or fails to provide such amenities, in that situation, it will be deemed to have been made by fraud, coercion and declared void by the tribunal. ये बड़ा स्पेशल लॉ है. देखो, हमारा यूजुअली हमारा गिफ्ट का कॉन्सेप्ट अलग होता है, राइट? So once the gift has been accepted, it has been accepted. You can't revoke it unless and until there is a clause of so. So here, because this is a special law, it has to be seen in context of what is the idea of the law, right? Constitution ko padhne chahte hain, if there are ambiguities, if there are loopholes in the constitution, we go to the constitutional history. We go, I was just recently watching some video, and students or maybe the audience had written that why are we studying legal history? For you to know why Mayors courts were established is very, very important for you to understand how the Supreme Court is working in this manner. The present Supreme Court has a lot to do with the federal court, has a lot to do with the Mayor's court established long back in 1700s. So, as a student of law, you should be woke. When you're, because I have time and there's so many people from different colleges, this is a practice which you will grow with time, that how do we read the law, start finding out that what is the nature of this law. If this is maintenance of parents and senior citizen, the idea of gift here is absolutely different. Therefore we see what is the purpose of law, right? Here when we are saying that it can be declared void, therefore the mother merely, if she goes to the tribunal established in this law and she proves that the person, the child, the son has stopped taking care of her, she can revoke and get back the property which she had gifted to the son. Now, what is important? The important factor here is that it should have been transferred with a condition that you will take care of me. So the interpretation in this case was with regards to whether it is mandatory that the son has to be made aware of that I am transferring you this property so that you will take care of my basic amenities. It can be, now comes the question that how the gift has been made. There can be implied terms also, express terms also, right? But interpretation of section 23 was done in context of the preamble. And I will take you to the long title of this law. The long title here says an act to provide for more effective provisions for the maintenance, right, and welfare of parents and senior citizens. So what are they basically saying? The use of this term that I've highlighted for you, more effective. That means we acknowledge that you can get maintenance on other laws as well, but this is a more effective way. How is it more effective? It has speedy in nature. So these are other things, that these are other principle and special features of this law. Then it talks about guaranteed and recognized under the constitution and for matters connected thereto. So basically, this law is promoting something from the constitution also. And then you go back, just read Article 45 and read Article 21. So constitution talks about a child which is less than 6 years, between 6 to 14 years, more than 14 years. But what about senior citizens? So senior citizens also have protection. This law is an extension, is to be seen with regards to that it is also promoting the constitutional principle. And from that, we get the idea that how do we really interpret these law? If I am interpreting constitution versus I'm interpreting a penal law, what will be my mode of interpretation? Where will I be more liberal, constitution or penal law? Okay, sorry. This is open. Yeah. My question is, if I am interpreting two laws at the same time, one is constitution and on the other side, I am interpreting penal laws. Yes. So the type of laws that I was talking about, right? It is not only that what is the purpose of the law. You also have to see what is the nature of the law. If the nature of the law is penal, then it is strict in nature. Okay. Provision of special law will prevail over general law. Yes. Okay, I will read all your comments also. Okay, but constitution has to be liberal. So there are cases, wherein time and again, in this case also, Urmila Dikshit also, it has been so mentioned by the court. So I'll just show you the judgment as well. This case specifically talks about the purposive rule of interpretation. Yeah, see how they've said. The provision of a beneficial legislation like Consumer Protection Act is beneficial legislation. So right now there was, a very famous case wherein we were discussing and trying to find out that whether Consumer Protection Act will be applicable on advocates or not. What do you think? Should it be applicable on advocates? Consumer Protection Act. Okay, why not? If you say yes or no, which rule of interpretation? No, if see, what if a strict interpretation violates? Exactly. So, see, when we are talking about Urmila Dikshit, a case like this, when we are talking about these type of special laws, we have to be mindful and we have to see that what will really promote the idea of constitution. Will it be this, or will it be, taking or opting for a strict rule? Okay, and that is how you accordingly. For example, there was another case. A case based on disability rights of people. So there was an MBBS student. The name of the case is Omkar versus something. I'll just give you the name of the case also. Omkar versus Union of India. Yes. So what has happened in this case is that there is an MBBS student, and he is absolutely fine. He has qualified the NEET exam. He wants to join the college, the most qualified college of the medical field, okay, in Delhi, and he's absolutely fine. But there is a law, and the law says that if you have more than 40% of the disability. Yes, Harshit, I'll just take up your cases, okay? I'll just wind up and take up your questions. So this basically this law here says, with regards to disability, the notification of colleges says that if you are more than 40% disabled, you have to go to the medical board and get your medical done and then submit the report. Okay, he does the same, and the medical board says that just because you're more than 40%, we will not allow you. The medical board did not allow him. This comes to the Supreme Court, and the Supreme Court again goes into the idea of constitution, whether to opt for liberal interpretation, and the idea of purposive rule of interpretation. So this law, that is the law or representation of peoples with disability act, the law here is to promote people with disability and not demote them. The simplest thing that we're trying to understand, right? And the High Court could not really get so the Supreme Court corrects and says that the nature of the law is it is a beneficial legislation. And when it is a beneficial legislation like this, Consumer Act, as I told you, you have to take a liberal view. You have to opt for a liberal view and try to help the parties. Okay. So I'm just giving you certain examples from the last year's case only, which you can mention. Okay, let me just see. Okay, we are up with our time. I'll now take your case questions. So Harshit has asked, could you please explain the concept of complementary you covered in contract? Yes. Harshit, I'll show you the screen again. Basically, when we opt for reading of Indian Contract Act, the preamble here tells us that whereas it is expedient to define and amend certain parts relating to contract. So first, we get an idea from reading of it. We, as in the law students, the lawyers, judiciary, everybody, legal scholars, we understand that this law is not exhaustive. And therefore, this law is in complement to other laws. So if you have not studied, you will study later maybe in your college that we also have Transfer of Property Act, for example, and Sale of Goods Act. Okay, we have these two laws. Both of these laws cover dealing with movable and immovable property. Let's say if you want to rent a property, you will rent it, which is called as lease, and there will be a lease deed, which is nothing but a contract, but not mentioned in Indian Contract Act. So Indian Contract Act now will be read with what? Will be read with Transfer of Property Act, which talks about lease. And therefore, this is complementary. Does that lease deed have to have free consent? Yes. The free consent is not mentioned in Transfer of Property Act, but it is mentioned in Indian Contract Act. And that is why these two laws are complementing each other. So when any specific law uses the term consolidated in the preamble or in the long title, the legislature, by using that one term, is giving you an idea that every rule related to Evidence Act is mentioned in the Indian Evidence Act or the BSA, right? On the other, when this term consolidate is not mentioned in Indian Contract Act, they have given you an idea that this law is complementary. If you go for Sale of Goods Act, you will have to find out and you will see that the principle of Indian contract are applicable when you're selling goods also to people. Okay, I hope I was clear. Palak has asked, how can judges use legal rules to interpret law while also ensuring fair outcomes, especially in tough cases involving marginalized groups strictly followed the... No, yes, exactly. So when we talk about marginalized groups, okay, Palak, there is a case, Sukanya Shanta versus Union of India, wherein there are prisoners and the prisoners are discriminated on the basis of caste. The Supreme Court corrected, the Supreme Court has given them an ultimatum that all these states in their registry have to ensure that they do not follow this caste based discrimination. How did we do that? We did that by reading the essence. Okay, even though this is so mentioned in the law, in the state laws, right? But we go by what is there in the constitution, and so the judiciary will always opt for liberal outcomes whenever we are talking about the marginalized group of people, no matter what it may be. Okay, we have a case of MK Ranjit Singh versus Union of India, again related to the people who are living in the state of Rajasthan, how the ecology gets affected if the great Indian bustard, that is one of the birds that are at the verge of extinction. So the Supreme Court again here takes cognizance of the fact that the ecology, the people living there, the tribal people living there, all of these have to be, their rights have to be protected. So it will be done in that manner. Is consolidated and construed? No, they are not the same. Construed is construction, construing. Okay, so it's a different term altogether. Okay, consolidated is a term which we will see in the title or in the preamble. Construe or construction is how you interpret and how you read it. Okay. Could you please explain concept? Okay, this I've done. Whatever strict interpretation, we have done this. Okay, any other question that any of you have? Which Rama Krishna Baba, what is that example that I had given? Can you please tell me? And I'll explain it. Yes, any other questions? I did not say Indian Contract Act is exhaustive in nature and yet can be interpreted. Okay, how is that the Indian Contract Act is exhaustive and yet can be interpreted? Okay, first, it is not exhaustive. Okay, second, because it does not uses the term consolidated in the preamble, so it is not exhaustive. But if, let's say, Indian Evidence Act uses the term exhaustive, that does not mean that it can't be interpreted. Exhaustive is with regards to the content in the law, that every principle of evidence is mentioned here. Okay, every aspect of evidence is covered here. But when we talk about Indian Contract Act, do you think every aspect of contract is mentioned in the Indian Contract Act? No. As I was telling you, the contract can be in writing but not mentioned. It can be mandatorily be in writing. When you refer to a sale deed has to be in writing, it has to be registered, it has to be attested, not mentioned in the Indian Contract Act. So Indian Contract Act is not exhaustive with regards to the concept of contract. What all can be there in a contract, okay? But when we talk about interpretation, that is allowed to be done in all types of law, whether it is exhaustive or it is illustrative, inclusive in nature. The extent of interpretation will vary. Okay, so if it uses an interpretation clause, the liberty given to you is a lot more as compared to the liberty that you have when there is a definition clause. Okay, yes. Any other questions? Okay, thank you, Sneha. Okay, so Kushbu, I think there are no other questions. We can stop here.
Yes, ma'am, we can. Thank you so much, ma'am, for such an insightful and engaging session. I'm sure everyone here has gained valuable knowledge. To all the participants, thank you for your energy and focus today. Don't forget to fill the feedback form and also review the session. And until the next time we meet again, stay curious, keep learning, and take care. Have a great evening, everyone. Thank you. Thank you once again, ma'am.
Thank you. Thank you, all of you. You can follow me on LinkedIn if you want to personally connect. Okay, that can be one way. Yes. All right. Thank you, all of you.